Welcome to tonight's Social Context of the Law Symposium. Should UK judges and ex-judges be sitting in Hong Kong? Let me start with a very quick pen sketch to set the scene. You'll all know that Hong Kong Island was acquired by Great Britain in 1842. Further bits were added to it, in particular in 1898, when Great Britain obtained the new territories on a 99-year lease. And not quite 99 years later, negotiations commenced between the United Kingdom and the Government of the People's Republic of China, the PRC, on the future of Hong Kong. That process culminated in a joint declaration in 1984, in which it was envisaged that the PRC should regain sovereignty over Hong Kong, but initially with a mini constitution lasting 50 years. That was formalized on the 4th of April 1990 when the basic law of the Hong Kong Special Administrative Region was promulgated with effect from the 1st of July 1997. And Article 2 of that basic law stipulated that the Hong Kong region is to exercise a high degree of autonomy and enjoy executive, legislative, and independent judicial power, including that of final adjudication, in accordance with the provisions of this law. So to 1997, when the PRC formally resumed the exercise of sovereignty over Hong Kong, and legislation was then enacted to replace the Privy Council with the Court of Final Appeal. Section 16 of the Hong Kong Court of Final Appeal Ordinance provides that to hear appeals, the court must have 5 judges, including 1 Hong Kong or overseas non-permanent judge, and the first Chief Justice, the Honourable Andrew Lee, established the convention that in most appeals, the bench would include a visiting foreign judge. On the 8th of September 1997, the then Lord Chancellor, Master Irvin, and the Chief Justice of Hong Kong agreed that the House of Lords would provide 2 serving law lords to sit on the newly created Court of Final Appeal as part of the UK's continuing commitment to safeguarding the rule of law in Hong Kong. And we move forward 20 years. Lord Neuberger, then the President of the United Kingdom Supreme Court and a sitting judge on the Hong Kong Court of Final Appeal, was reported as saying that the time could come when it would be right for all foreign judges to quit the Hong Kong bench. Giving a speech to Hong Kong University in 2017, he suggested that the foreign judges were, quotes, canaries in the mine. As long as they are happy to serve on the court, then you can safely assume that all is well with judicial independence and impartiality in Hong Kong. But if they start to leave in droves, that would represent a serious alarm call. On to the 30th of June 2020, the law of the People's Republic of China on safeguarding national security in the Hong Kong Special Administrative Region was enacted, introducing crimes of subversion, secession, terrorism, and collusion with foreign powers. This was said to be a breach of Article 23 of the Basic Law, which provides for Hong Kong to bring forward its own national security legislation, which it had tried but failed to do in 2003. Foreign judges are not permitted to hear cases arising under the new law, while judges chosen by the executive for national security cases can be removed from the list if their words or deeds endanger national security. I should now read at a little length from a statement by Master Reed, the President of the UK Supreme Court, on the 17th of July 2020, concerning that new security law. He said it contains a number of provisions which give rise to concerns. Its effect will depend upon how it is applied in practice. Undoubtedly, the judges of the Court of Final Appeal will do their utmost to uphold the guarantee in the Basic Law that the courts of the Hong Kong Special Administrative Region shall exercise judicial power independently, free from any interference. As the Chief Justice of Hong Kong, the Honourable Geoffrey Ma, recently said, the independence of the judiciary and the rule of law are cornerstones of the Hong Kong community, and they are guaranteed under the Basic Law. The Supreme Court, continued Lord Reed, supports the judges of Hong Kong in their commitment to safeguard judicial independence and the rule of law. It will continue to assess the position in Hong Kong as it develops in discussion with the UK government. Whether judges of the Supreme Court can continue to serve as judges in Hong Kong will depend on whether such service remains compatible with judicial independence and the rule of law. On the 2nd of September 2020, James Spiegelman, the former Chief Justice of New South Wales in Australia, resigned from the Court of Final Appeal, having been on it since 2013, and he told ABC News his decision was related to the national security legislation. On the 12th of November 2020, the Foreign Secretary declared that a decision by the Chinese National People's Congress breached the Sino-British Joint Declaration. And on to this year, on the 11th of March 2021, Lisa Nandy, the Shadow Foreign Secretary and one of tonight's speakers, Lord Falconer, the Shadow Attorney General, called for the UK judges to withdraw in recognition that the rule of law was endangered by Beijing's crackdown on democracy. They said that the presence of UK judges on the Hong Kong court serves only to legitimize a compromised political and legal system. And they continued, while it had been hoped that the continuing role of UK judges could help preserve judicial independence and the rule of law in the face of the actions of the Chinese government and Hong Kong authorities, the sustained campaign to undermine democracy has fundamentally changed the context. They added that it had become, quotes, increasingly clear that the national security law, the wider actions to arrest and intimidate opposition figures, and the latest decision of the National People's Congress are fundamentally prejudicing the political and legal system in Hong Kong. On the 15th of March 2021, The Times reported, Lord Neuberger has defied critics to extend Hong Kong post for 3 years. But in doing that, he joined Lord Walker of Gestingthorpe, another former Supreme Court judge, and Mr. Justice Murray Gleeson, the former Chief Justice of Australia. A couple more words on the Court of Final Appeal. Foreign judges, along with permanent judges and non-permanent local judges, are appointed by the Chief Executive on the recommendation of the Judicial Officers Recommendation Commission, an independent commission chaired by the Chief Justice. Overseas non-permanent judges come on a rotational basis for a month at a time. Master Reed and Lord Hodge, Deputy President of the UK Supreme Court, are both on the list of non-permanent overseas judges that sit on Hong Kong's court, and they're joined by 3 former presidents of the Supreme Court, Lady Hale, Lord Neuberger and Lord Phillips, 2 former Supreme Court justices, Master Sumption and Lord Collins, and 3 former members of the Judicial Committee of the House of Lords, Lords Hoffman, Millett and Walker. 3 Australians and 1 Canadian round out the group of overseas judges on the court. Let me give you 2 opposing viewpoints on tonight's topic. The first from Nathan Law, a leading democracy campaigner who left for London because of the new law and was granted political asylum here in April 2021. He has called for the judges to quit. He said that the territory's legal system has been, quotes, fundamentally undermined by the Chinese government's steady suffocation of Hong Kong's autonomy. By serving in Hong Kong, British judges therefore giving a veneer of credibility to a system which is now utterly lacking in legitimacy. And as against that, Lord Panic, who often appears in Hong Kong courts, argued that the British judges should remain. He said the Hong Kong judiciary is doing all it can to maintain its independence. Labour politicians here should listen to the legal community in Hong Kong, most of them no friends of Beijing. They want to be supported by lawyers and judges in this country, not abandoned. And finally, a word from a man on the spot, Paul Harris, the chair of the Hong Kong Bar Association, who spoke to our Bar Council 2 weeks ago. He said the worst possible thing that could happen to us practicing here in Hong Kong is if those overseas judges leave. I'm aware of the voices that have been raised in the United Kingdom saying the judges should be withdrawn. I cannot emphasize too strongly how much I disagree with that and how utterly damaging that would be. I'm quite certain that the overwhelming majority of lawyers here, barristers and solicitors, would feel exactly the same way. And so, ladies and gentlemen, with that introduction, on to tonight's speakers. First, Master Falconer, Baron Falconer of Thoroton, Privy Councillor. Charlie was called to the bar in 1974, took silk in 1991, was created a life peer by the Prime Minister in 1997, and joined the government as Solicitor General. After a series of government posts, he joined the Cabinet in 2003, becoming Secretary of State for Constitutional Affairs. He is currently the Shadow Attorney General. David Neuberger, Baron Neuberger of Abbotsbury, holder of the Gold Bauhinia Star, Privy Councillor, Honorary Fellow of the Royal Society, was also called to the bar in 1974. took silk in 1987, High Court judge in 1996, Lord Justice of Appeal in 2004, Lord of Appeal in Ordinary in 2007. His rise to the Court of Appeal and then to the House of Lords is one of the quickest in recent times. Lord Neuberger was the youngest sitting Law Lord, but he didn't stop there. He became Master of the Rolls in 2009, President of the Supreme Court in 2012, and a non-permanent judge at the Hong Kong Court of Final Appeal. He was more or less forced to retire in 2017 from judging, but is now very active as an arbitrator and in many other roles, including his continuing membership of the Court of Final Appeal. It's worth adding for the aspirant barristers in the audience that Lord Neuberger's pupillage set decided not to take him on as tenant or fools they, so there's hope for everybody. And now, please, with that introduction, can I call please on you, Charlie, to start us off this evening?
Guy, thank you very much indeed. And thank you particularly for that very clear introduction, putting the story in context. I feel, although I think it is a very difficult decision, that it is wrong for the President of the UK Supreme Court and the Deputy President of the Supreme Court, the two senior office holders in the UK judicial system, to continue to sit in the Final Court of Appeal, the Court of Final Appeal in Hong Kong. I think people such as David are in a different position. They no longer hold state judicial office, and the decision for them is a decision genuinely for them, and it's for them to make up their mind in relation to it. But I think it is wholly wrong now for the UK state to give the appearance of endorsement to what is going on in Hong Kong, and in particular, the position of the rule of law. I have absolutely no quarrel with a number of the propositions that were advanced by both David Pannick and Paul Harris in the quotes that came from Guy. If you went to Hong Kong now, unquestionably, you would find the judges there doing their best and succeeding in deciding cases in an independent way and in accordance with the law. If you went and spoke to the legal profession in Hong Kong, they are incredibly keen that the foreign judges continue to operate there. And the reason that they are keen for it is because of the huge contribution that the foreign judges have made in relation to the development of jurisprudence in Hong Kong, and in providing solidarity to Hong Kong judges who from time to time, like all judges, come under pressure from circumstances. But the reason it is wrong for the President and Deputy President to continue to sit is because there is this gaping hole in the rule of law in Hong Kong. And that gaping hole is not explicit pressure on the judges. It is the obvious, inimicable approach that the Chinese government has started to take to the law. Now, the national security law is absolutely the clearest and most glaring example of it. You have to take the national security law in full. It creates a number of offences that we would regard as being pretty restrictive of people's freedom of expression and freedom of protest. Those will be dealt with by the courts, and the courts will probably be compelled, as they have been in the last few months, to give effect to these draconian laws that would never be acceptable here. But as Jonathan Kaplan reminded me yesterday, about 30 years ago, he had to appear for a man called James Agee, who had to explain to three wise men why he shouldn't be expelled from Britain without being told why it was he was being expelled from Britain. So every country had these sorts of gaps. But more significant than the oppressive nature of the new criminal offences is Article 55, which Guy referred to, which allows something set up by the National Security Law called the Office for Safeguarding National Security of the Central People's Government in the Hong Kong Special Administrative Region, a government body, a body of the Chinese government. It allows them to exercise jurisdiction over a case concerning endangering national security. If this office, the Office for Safeguarding National Security, takes the view that, quote, a serious situation occurs where the government of the region is unable to effectively enforce this law, then they can determine what should be investigated. They can determine where it's tried. In effect, what's happening is that the PRC has taken to itself the power to get round the judges in Hong Kong. So if, for example, even under this draconian law, convictions are not obtained or investigations are not pursued, then the PRC can, in effect, choose who to investigate, choose how they're tried, choose where they're tried, and choose what happens to them. You cannot have a system which purports to be the rule of law where there is a parallel system where the executive can do what it likes in relation to those who are its enemies. This has also, I believe, to be seen in the context of the way that the Chinese government has treated lawyers in England who have had the temerity to express views entirely in accordance with the law in the UK, unfavourable to the Chinese government. And as everybody knows, they sanctioned a number of sets of solicitors and a set of chambers, because on the Chamber's website was an article by one of the members of Chambers expressing critical views of the Chinese government's record towards human rights. Sanctioning lawyers for doing that shows utter contempt for the law. None of these things alone would necessarily lead to the conclusion that the President and the Deputy President of the UK Supreme Court, which is a beacon to the world, should continue to stop. But taken together, coupled with the PRC's crackdown, the idea that our two apex judges should be giving cover to that legal system, which I make clear involves no criticism of the individual judges who are doing their best without a shimmer of a shadow of doubt. Plainly, I think David was right in his speech in 2017, and he put it incredibly well, because what he said there was the critical reason for the apex judges being there. Of course, it's hugely beneficial to Hong Kong to have judges of David and Lenny Hoffman and Brenda Hale and Nicholas Phillips and James Spiegelman's quality there, but much more important than the quality, because there are a lot of brave judges of huge quality within the Hong Kong itself, is the canaries in the mine thing. Staying, and the British government saying that the apex judges can stay, is saying the rule of law is fine in Hong Kong. It most certainly is not fine, because there is this massive hole. And that is why I and the party of which I'm a member strongly take the view that we side, unfortunately for me, not with the legal community, not with the legal establishment in Hong Kong, but with Nathan Law and what he says, which is that you should not be doing this. I make it clear that for David, it's a different position. He is, tragically for the British legal system, no longer the president of the Supreme Court, but it's a choice for him as an individual. For me, the big thing is the two apex judges, and they should not be lending their authority for what's going on in Hong Kong.
Charlie, thank you for that. So, David, it looks as if the heat is off you. You can carry on as a canary in the mine for so long as you feel it appropriate to do so. But Charlie is really getting at our two Supreme Court justices. That's where he's directing the focus of his argument. And now, what do you say?
In a sense, I'd like to divide what I've got to say, like Caesar divided Gaul, into three parts. First of all, the arguments as to why UK judges, ex-judges, shouldn't be sitting in Hong Kong, although Charlie has limited his attack to UK serving judges. Secondly, reasons why they should. And thirdly, consideration of the special position of the Supreme Court judges. In what Charlie and Lisa Nandy said, their first observation concerned democracy. Democracy and the rule of law are two cornerstones of our system in the UK, but they are quite independent of each other. Hong Kong under British rule provides a very good example. There was no democracy of any sort during our 155-year rule, save for a very pallid sort of democracy in the last year or two before we handed over to the PRC. Yet there's no doubt that Hong Kong had the rule of law since 1945. So while there may have been a curtailment of democracy in Hong Kong, it doesn't impinge on the rule of law. So far as the rule of law is concerned, the primary concern of judges, of course, is independence of the judiciary. I don't have to spend much time on that because, as Charlie has fairly accepted, the judges are independent. I'm aware of no more pressure on the judges from the government in Hong Kong than I was aware of pressure on the judges in the UK from the UK government. Charlie's concentrated more on the substantive law. Well, one has to be careful about that. No judge approves of every law which he or she has to apply. I disapproved of and still disapprove of much of the sentencing law in the UK. But even though it's an important topic concerned with liberty of the subject, that didn't stop me acting as a UK judge. Nor did the fact that capital punishment exists in most Caribbean countries stop me acting as a judge in the Privy Council on Caribbean capital cases. Of course, the law can become so bad in one's view that one finds it unacceptable that one has to administer it and one steps down. But in my view, there's no reason to do that in Hong Kong at the moment. Now, what about the national security law on which Charlie concentrated? Bit of context first. Article 23 of the Basic Law, which was approved years before the UK agreed that UK judges would be sitting in Hong Kong, and was part of the settlement effectively, which started when Hong Kong started under PRC rule, provided that the Legislative Council of Hong Kong would have a national security law, would pass the national security law. It was part of the deal. After 20 years, the Hong Kong Legislative Council failed to do it. So it's scarcely surprising that the PRC, because Hong Kong is part of the PRC, stepped in and passed it. So before we leap into action, we should see what actually happens with this law. All countries, as Charlie fairly accepts, including the UK, have laws which protect national security. And those laws almost always include provisions which appear draconian, at least to some people, and which can be misused or abused. But let's see if they are misused or abused. As Lord Reid said in the passage which Guy quoted, the effect of the national security law will depend on how it's applied in practice, and we should wait and see. Charlie concentrated in particular on the ability of the PRC to bypass effectively the Hong Kong judiciary on national security cases in Article 55 of the security law. Well, it can only do so in three types of circumstance. First, where the case is complex due to the involvement of a foreign country or external elements, which makes it difficult for a region of China, which is what Hong Kong is, to exercise jurisdiction. Secondly, where the government of Hong Kong is incapable of enforcing the law. And thirdly, where there is a major and imminent threat to national security. In those circumstances, what is effectively being said is that it must be handed over to the federal government, if you like, to the Chinese government. Those provisions would not be surprising to anyone who was in this country 30 or 40 years ago, when until the GCHQ case, everyone believed that when it came to matters of national security, the courts couldn't step in at all. That was changed by the House of Lords. But that's the sort of circumstance where I think one has to wait and see how this law is applied. Going back to what Lord Reid says, let's see what Beijing does about it. Let's see how it's enforced. And indeed, there's always been what I might call a Beijing override in Hong Kong law. Article 158 of the Basic Law provides that the so-called National People's Congress Standing Committee can overrule the Court of Final Appeal. And that's been there, part of the law of Hong Kong from day one when China took over, and we agreed to it, and it's what the law was when we agreed to UK judges sitting there. Charlie touched briefly on the treatment of demonstrators. By UK standards, I accept the sentences could be said in relation to peaceful demonstrators to appear excessive. As a serving Hong Kong judge, it's not for me to say whether I think those sentences were or were not appropriate. But different countries have different circumstances. There had been violent demonstrations. There had been severe disruption and invasion of LegCo, the equivalent to what we saw on the 6th of January in the United States in Washington. And the transport system, when I was last in Hong Kong, was shut down continuously by demonstrators. There was a point about law and order there. Let's see what happens to sentencing. Many of us will remember the fairly strong sentences, unusually strong ones, that were imposed on the Tottenham rioters in 2012, when it was seen that many of the stiff sentences were imposed as a warning. What about the positive arguments in favour of staying as a Hong Kong judge? First of all, support for the rule of law in Hong Kong. The NPJs, as I think Charlie has fairly accepted, undoubtedly help to maintain the rule of law. They provide internal support for and reinforce the credibility of the Hong Kong judiciary. Support for the rule of law is vital for maintaining the Hong Kong Constitution, in which the UK played such a part in setting up. It's vital for protecting the basic law rights of the individual people in Hong Kong, and it's vital for the extraordinary economic success of Hong Kong being maintained. It would require, I suggest, a very clear case before UK judges should walk away from that, particularly UK judges. The UK was responsible for Hong Kong for over 150 years. And as I say, not a jot or tittle of democracy till the last 2 years. But much more importantly, we have a substantial responsibility for the basic law, and therefore the UK government has, as it is honourably recognised, a special responsibility for the people of Hong Kong, and therefore for the maintenance of the basic law. It seems to me extraordinary that it should be said that at the sound of gunfire and the sound of problems, we should walk away. Our duty is surely to stay as long as we can, to stand up for the values enshrined in the basic law, which is still very much alive and effective. The solicitors, the barristers, business leaders, all have publicly said that they're very keen to keep the overseas NPJs. They're all groups of people who are dependent on the rule of law, who are supportive of the rule of law, and who are knowledgeable about the rule of law and circumstances in Hong Kong. And the Hong Kong judges want us to stay. They're valued and respected colleagues who we should be supporting as long as we can. And what would we achieve by standing down? It's laughable to think that the PRC would change its policy in the way that Charlie might hope. On the contrary, the very fact that he accepts by remaining the NPJs would support the rule of law means that by implication, by going, we would do the opposite. So it would be worse than pointless. It would be counterproductive. As for the argument that by remaining, the NPJs are giving an unjustified impression of respectability to the Hong Kong judiciary, the truth is that it's an entirely justified impression. We're only going to stay so long as the Hong Kong judiciary is truly independent. If we want to antagonize the PRC to the positive disadvantage of this country and Hong Kong, and in a way that achieves nothing, then we should stand down. It goes further than that in terms of the UK interests. The common law is of enormous value to the UK in terms of soft political power and earnings through legal services. It will scarcely do us any good if UK NPJs withdraw from Hong Kong. It still has its Canadian and Australian judges. And it's striking how former UK judges continue to sit in Dubai, Qatar, Kazakhstan, Singapore, and Caribbean courts of appeal. So why not Hong Kong? Finally, I turn to the position of the Supreme Court justices. I accept, of course, that serving UK Supreme Court justices are potentially in a different position. Unlike retired UK judges, they have a primary and overriding duty to the UK Supreme Court, and they are servants of the Crown. Nonetheless, subject to that, the arguments I've rehearsed apply with equal force to them. 2 serving law lords were offered by Lord Irvine, Charlie's predecessor, by the UK government to Hong Kong in 1997, when Hong Kong had a pallid democracy, 8 years after Tiananmen Square, and when the basic law was in place, providing for a national security law and for the Beijing override. Having Supreme Court judges sitting outside the United Kingdom is not anomalous. Supreme Court judges regularly sit in non-UK jurisdictions in the Privy Council. And of course, as I've already said, in countries which have the death penalty, for example. I would not presume to tell UK Supreme Court judges what they should do, but the mere fact that some politicians and some journalists say that they should not be sitting in Hong Kong is not a good reason for them standing down. While judges should not ignore publicly expressed opinions, it's part of their job to make right and unpopular decisions. Thank you, Guy.
Gosh, the pleasure of listening to great advocates. Charlie, at the end of your 10 minutes, I was thinking, what on earth is David going to be able to say to come back to that? And now I've listened to David and I'm thinking, what on earth is Charlie going to say in reply? Well, Charlie, you will get your chance in a moment. Let me first put some questions to both of you, which you can either answer now as you choose or weave into your replies. The Times March 21 article that I mentioned had a blog underneath, and one of the commentators said, well, whatever the judges' intentions, the Communist Party of China will use their presence to justify their own judicial system. It is the CCP way. As they are being kept away from the contentious political cases, their actual judicial impact is essentially no different to an indigenous judge. Whichever way you cut it, they are doing the Communist Party of China a massive favor by being there. So that's certainly a view held by somebody in this country. It seems to have legs. Is there a comment you'd like to make now, or do you want to save it for your closing speeches?
I mean, speaking for myself, I agree with that comment, which is that it is obviously of real value to the PRC that the judges continue to sit, because in terms of world opinion, it means they can say we've got a perfectly okay legal system, which allows us to have this massive crackdown. And if we want, we can draw people away from the existing legal system. So I agree with that comment quite strongly. I don't want to take the opportunity of replying to everything that David said, but for me, the absolutely key point is not the independence of the individual judges, which I completely accept. It is the ability and the willingness of the PRC to be able to go round the judicial system. David referred to Dubai and Qatar, where very distinguished English judges sit in the commercial court there. The idea that those judges, if you ask them, would say Dubai or Qatar live by our standards, by the rule of law, is absolutely nonsense. It's a completely different issue in relation to Hong Kong, where the weaving into the agreement that was reached of the non-permanent judges was to say the rule of law, which was a strong aspect of the deal, continues to be upheld. David is right to say the basic law gave the PRC the ability to override decisions of the Court of Final Appeal. That was part of the deal, setting out what the overall constitutional position was, but it was plainly done on the basis that the rule of law would prevail in Hong Kong, which it did for 10, 15, 20 years. That has changed is what changes the ability of the NPJs to stay, and in particular the two apex judges in the UK.
David, do you want to come?
Yes, I think that Charlie refers to the ability of the PRC to get round, as it were, the courts. And that's entirely the point that Lord Reid was making in the passage which you said, quoted, and I briefly referred to. We've got to see whether they do that. If they have limited powers, which in themselves are not abused or misused, to decide cases where they are inappropriate for the Hong Kong court because they involve national considerations for some reason or are not enforceable, then it's hard to object. If it's misused and they take cases away from the Hong Kong courts because they don't like what the Hong Kong courts are doing, then it's a different matter. But to jump in before the national security law has been tested in that way seems to me to be quite inappropriate. So far as the precise question is concerned, the blog comment, justifying their own judicial system, we're not justifying or enabling the PRC to justify its judicial system outside Hong Kong. We are, I accept, enabling them to justify their judicial system in Hong Kong. But so long as their judicial system is independent, what's wrong with that? So I have no quarrel with that statement. We are like indigenous judges in one sense. We're indigenous judges of Hong Kong. And so long as the Hong Kong judiciary is independent, we're happy to support it. Subject to, as I say, to exceptional circumstances, but I fundamentally disagree with Charlie that those exceptional circumstances have yet arisen. And I hope they do.
David is in a sense going back on the 2017 speech that Hong Kong judges are not canaries in the mine. They are there. The reason why, as you rightly identified, David, in your speech, that there are NPJs of your quality is because you are in a position where by staying, you have a choice and you are giving an imprimatur to the continuing safety of the rule of law. And nobody could say that the indigenous judges are canaries in the mine. You yourself rightly identified that as one of the purposes of there being NPJs.
Yeah, I agree with you.
You're stepping away from that because you're saying, in effect, well, the Hong Kong judges are acting independently, which they are. They're doing their best. They're entirely admirable as a group of people. I should stay to support them. Yes, as long as your canaries in the mine role is being discharged. And the essence of my case is that it is not.
Well, that's the essence of your case, but it's a case that I disagree with because I do not think the rule of law is yet being interfered with. In a sense, the rule of law is always being chipped away at the edges in different ways in different countries. But to my mind, the rule of law is still alive and kicking in Hong Kong. And I agree that we should be canaries in the mine, as I said. But to me, the oxygen for the canary is still there, enough for me to be able to sing rather than to droop.
Very good. Let me move on to a different question, which is really concerned with the notorious sanctions which were announced by the PRC 2 or 3 weeks ago now. Sanctions against one of our sets of chambers in London, against one of our Inner Temple benchers, against various MPs, because of their having been outspoken about various aspects of human rights in China. Now, here's the question. Is it appropriate or ethical for a serving United Kingdom Supreme Court judge to sit on the Court of Final Appeal in a jurisdiction which is ultimately subject to PRC control when the PRC has announced those sanctions on UK citizens without their having had any chance at all to challenge the basis upon which those sanctions may have been imposed? Who'd like to take that? David.
I think the first point I have to make is that when I last looked into this, it was actually unclear whether the sanctions have actually been imposed. They've certainly been announced, but there appears, and I can't say I've looked into the law, but I have read a couple of articles, more than a couple of articles about it, and talked to 1 or 2 people about it. And it appears that there is a procedure for imposing sanctions which hasn't been gone through. And the view among the academics I've read is that actually the sanctions are not formally in place. But assuming they are entirely regrettable to us with our UK approach to life. But they are not imposed by the Hong Kong government. You can certainly say that it's unattractive for us to see them being imposed. But if we object to what the Chinese PRC government does, then as I say, we agreed to UK judges sitting in Hong Kong 8 years after Tiananmen Square. We're not looking at what Beijing is doing. We're looking at what Hong Kong is doing and what Beijing is doing in Hong Kong. I don't say anything about the sanctions, but if they are imposed, I can't say I'm enthusiastic about them, but I don't think they undermine the fact that we're Hong Kong judges carrying out our function in Hong Kong, and the fact the Beijing government does, as it were, at a higher level, things that we may not like, but that do not relate to our role in Hong Kong, should not, in my view, prevent us from sitting in Hong Kong.
If all that had happened was that, then I do not think that entirely on its own, out of a wider context, would have justified saying that the NPGA should stop sitting in Hong Kong. But coupled with everything else, it seems to me to be the clearest possible sign of the absolute contempt that the PRC has for the rule of law, that you could attack lawyers thousands of miles away because they criticized you, indicates that they, the PRC, want lawyers to be quiescent to the state. And if they're willing to do that for foreign lawyers, they would assume, I assume, seek the same from both Hong Kong lawyers and local lawyers. For me, it's part of an appalling picture that makes it harder and harder for the NPJs to continue to sit. David is obviously right that lots and lots of judges and lawyers have profound disagreements with laws in England. That wouldn't remotely stop them being judges or lawyers. This is much more fundamental. It is a government that, 8 months ago, passed a law saying if we don't like the justice we get from the Hong Kong courts, we will exercise power ourselves to deal with people that are oppositional to us. And it's nothing like, with respect to David, the discovery in the GCHQ case that judicial review could overcome national security. That was in relation to whether or not unions could be banned from GCHQ. It did not say national security justifies us, the government, taking people, deciding how they're going to be tried, deciding how they're going to be investigated, and deciding how and where they're going to be punished. It is fundamentally different, and is fundamentally an attack on the rule of law.
I think, first of all, the slight giveaway in the earlier part of that answer was the words "I assume." The Chinese government hasn't done anything, or the Hong Kong government hasn't done anything to prevent lawyers and judges carrying out their functions in Hong Kong. Charlie assumes that because they've issued these sanctions against other people outside the country, they will do so in Hong Kong. Well, it comes back to Lord Reed's point yet again. Let's wait and see. It hasn't happened yet. As for Hong Kong government, the Chinese government showing contempt for the judiciary and the rule of law and taking away cases from Hong Kong, whatever they may say, let's wait and see what happens. So far, it hasn't happened.
David, the fact that they have attacked English lawyers presumably indicates what they expect of lawyers, because even foreign lawyers are being attacked for this. And then secondly and separately, on your point, let's wait and see what they did. Why on the 20th of June in secret did they pass a law that gave them the right to snatch people out of the jurisdiction of Hong Kong? Why did they do it? Not to use it. They did it for one of two reasons. Either they did it because they wanted to use it, or they did it to say to the Hong Kong judicial system, if you don't go along with the rest of this law, we'll do it ourselves.
Again, let's see what happens. It's all very well saying it. I'm not defending everything the Chinese have done, but even so, let's see how the rule of law actually is functioning in Hong Kong, rather than us asking ourselves why this happens or assuming that may happen. I think we can't let down the people of Hong Kong on what we think may happen or what we assume may happen or what we feel. We've got to look at the hard facts. And until the hard facts make it clear that the rule of law is not applied in Hong Kong or the judges are not independent, I just don't think we should be letting down the people of Hong Kong.
But why is the passing of Article 55? Why is the sanctioning not the facts?
Article 55 does apply to Hong Kong, but in its terms, it's not particularly objectionable. And until it's used in an objectionable way, I think it's misconceived to try and invoke it as a reason for pulling out. So far as sanctions are concerned, that has been a decision of the Beijing government. It has not specifically applied to Hong Kong. It has not applied to any Hong Kong judges or lawyers. And we've got to see what happens there.
I mean, David, you must find the terms of Article 55 objectionable. It would be objectionable in any state for the executive to be able to say a government department can determine how and when you will be investigated, how and when you will be tried, and what your punishment should be.
I think we first of all, you have to see this in the context of Hong Kong being part of China, in the same way as Article 158 entitles a government in Beijing to override a decision as to what the basic law means, even though the decision is made by the Court of Final Appeal. That doesn't stop and has never stopped any non-permanent judge going to Hong Kong and being appointed to sit in Hong Kong, and has never produced any objection from any government. In the same way as a UK Parliament can override any decision made by a judge. The only difference is that China is not a democracy, and their top body is not a democratically elected legislature. It is what we would call an organ of the executive, not the legislature. But so long as that's a system, and that's a system which we have handed Hong Kong back to, if there is to be an overriding right in the top federal body, as there is here in Parliament, to override what happens in the courts, then you've got to accept that's part of the system. It's not a comfortable part of the system for people like us, but until it's abused in a way that we find unacceptable, I think it's quite wrong to invoke it as a reason for pulling out, when it's always been part of the system once we handed back Hong Kong to the PRC, which has a non-democratic system of government.
David, can I just ask my last question, which probably goes to the crux of the difference between you. You, with respect and admiration, David, and not a canary. Well, if you are a canary, you have the most striking, remarkable yellow plumage of anybody in the legal firmament. Charlie, has no problem with you continuing to sit in Hong Kong. His problem is with serving judges. Now, what do foreign serving judges bring to Hong Kong? And what would be lost through their removal, given that people of your caliber can still sit there?
That's a fair answer, a fair question. And I think the answer is that by removing standing down, even a limited number of judges standing down, of the NPJ standing down, it would send a bad message, and it might well lead to the walls crumbling. I don't know. I can't predict. It may not have a great effect. But I think the logic of my argument, and the logic which seems to be in line with what Lord Reid says, but as I say, he must speak for himself, and I don't want to have my words, as it were, thrown at him. But his message seems to be, we are monitoring the situation. There are causes for concern, and to that extent, I entirely agree with Charlie. There are causes for concern, but we're monitoring the situation, and so long as it's acceptable, we will continue. If that's right for one canary, then it's right for all canaries. And in principle, unless there is a reason that affects the Supreme Court judges, as bearing in mind their primary loyalty is to the UK Supreme Court and bearing in mind they are Crown servants, then I think the logic of my argument is that they should stay. And I think the logic of Charlie's argument as to why the serving Supreme Court judges should go really means that people like me should go too.
I've extended this because it's been such a joy hearing you go backwards and forwards between each other, and so I've rather compromised the sort of closing speeches. So, Charlie, over to you now, and we're running slightly short of time.
The exchanges that I've just had with David rather encapsulated the differences between us. The appointment of the non-permanent judges, the deal that Derry did with Andrew Lee in 1997, was to support and cement the separateness of Hong Kong in the rule of law sense from the rest of China. As long as people of the standing of, in those days, 2 members of the Judicial Committee of the House of Lords, and then subsequently members of the Supreme Court, were willing to go on sitting, it was sending a message that Hong Kong lived and breathed the rule of law. The fact that the deal that had been done politically involved the UK having to accept the complete sovereignty of the People's Republic of China, which we did politically have to accept in order to do the deal, coupled with the fact that we were sending our judges, meant, okay, we accept the idea of the sovereignty of the PRC, but as long as the rule of law continues without being interfered with, that's fine. And the judges being there will indicate that it's not being interfered with, as well as all of the advantages that I mentioned, support for the existing judges, the indigenous judges, and also having really high caliber judges to develop the law over there. What I find so striking and so awful about the current position is that it is absolutely obvious that the PRC has decided to change its position in relation to Hong Kong, as is demonstrated by the attacks on English lawyers, as is demonstrated by the enforced crackdown on the demonstrators, as is demonstrated most of all by the passage by the PRC in June of the National Security Law, which is saying we take these powers in a way which is completely at odds, whatever David says, with what we would regard as the rule of law. It is the main protection that the rule of law gives is against arbitrary action by the executive. And this, however it's dressed up, is arbitrary action authorized to the PRC in relation to freedom, putting people in prison. And it is intended to send the signal that we will take power if the executive in Hong Kong doesn't do what we want. And that is the end, in my view, of the rule of law. Not in 95% of cases, because in 95% of cases there'll be no state interest engaged. And if the purpose of us sending those judges was as message carriers, as to say it's okay, then unpalatable as the message may be, they cannot give an inaccurate message. And above all, our Supreme Court President and our Deputy Supreme Court President cannot give a false message about what the rule of law consists of at the moment. They must come home. They cannot go on saying, we would regard that as acceptable, because there isn't a judge in the United Kingdom who would regard the state as taking to itself the power to snatch people and try them in any way they like, consistent with the rule of law. And that is why they've got to go, I think.
Thanks, Charlie. David.
I think, I don't know if I have a great deal to add to what I've said, but in my experience, when advocates say that, you then have to stop them because they go on too long. But I think that my main point is that, of course, things may not seem to us to be perfect. But when we handed back Hong Kong to the People's Republic of China, we achieved a very significant benefit for the people of Hong Kong, in that we ensured that they had the basic law, which was going to be enforced by an independent judiciary, buttressed and supported by the canaries in the mine, by UK judges serving and retired. And this was not just supporting the rule of law as an abstract exercise, it was supporting individuals' rights and businesses' rights in Hong Kong for the benefit of the well-being of the Hong Kong people and for the benefit of the Hong Kong economy. The basic law is still there. The judges are still independent. There have been some changes, particularly recently, and they may not be changes which particularly appeal to us. But one has to see them in the context of A, failures of the system in Hong Kong, not the judicial system, but the system whereby LegCo couldn't pass any laws because they were being blocked, or many laws, there were some laws that were passed, I don't want to exaggerate, LegCo was invaded, as Congress was in January this year, with much greater publicity. The transport system was cut down, parts of Hong Kong was occupied. LegCo had failed to pass the national security law, which was part of the deal with the PRC. In those circumstances, many in this country may feel by our standards that Beijing has gone further than the government here would have gone. But judged against the fact that we handed back Hong Kong to the PRC, knowing that the PRC would have the final say on the law in Hong Kong, knowing that there would be a national security law, knowing that the PRC did not have a democratic system, but had a system which was more monolithic, party controlled. I really think, seen in that context, for us then to criticize and then to throw our toys out of the pram by reference to laws which Charlie has expressed very clearly and very strongly, but laws which we have yet to see how they're to work out. Article 55, which he goes on about, we haven't yet seen implemented. And if it's not implemented, or if it's implemented in circumstances which are reasonable, then we'll look a bit silly if we have walked out on the basis of that. In my view, the proper course to take, bearing in mind our duty to the people of Hong Kong, our duty to the rule of law, is to stay until the water does become too hot, in the hope that it never does become too hot. But at the moment it hasn't. And as I said, the canaries should still be singing. As for the Supreme Court judges, while in principle the points I've made apply, there are, I accept, and Charlie agrees, potentially other considerations, and they'll have to make their own decision. But to my mind, the points I've made do apply to them as they apply to the non-serving UK judges. Thank you.
David, thank you very much. Now we have questions coming in from the audience. Let me put the first to you. This is really a question about the buttressing, the support for the local Hong Kong judges by your presence. And he asks, what of the support for the independence of the Hong Kong judges and the Court of Final Appeal as an institution? He says it's clear from the local judges, for example, Chief Justice Ma's regular articulation of this, that they are buttressed by their presence. So that's to say your presence and the Supreme Court presence, and given confidence in being as independent as they can. Now, Dave, to what extent is that a feature of your stance?
Well, I am very attracted to the idea of, as it were, we are in a world of diversity that appreciates diversity. The idea of having judges from other jurisdictions sitting in your top court is of enormous value to any court, I think. And the Singapore court has seen that. And I sit as a judge in the Court of Appeal in Singapore, and I am part of the system there, and only doing commercial cases. But I think they've seen the value of that. And in the case of Hong Kong, with a new system where there are potential frictions because of the PRC, having the support of foreign judges from a country with a long history of judicial independence, a long history of legal excellence, the original country that started the common law, is enormously valuable. That's what they say to me, and that's what they say to my colleagues, and it would be surprising if it was otherwise.
Thank you, David. Charlie.
I mean, from speaking to Hong Kong judges, it's absolutely plain that they do get both succor and support from having foreign judges sitting with them, both in the sense of buttressing their independence and in the sense of the interchange helping to provide new insights and improving the quality of the judgments that are given. But ultimately, the question is, has the rule of law been compromised? And as I've made absolutely clear throughout everything I've said, I have no doubt that the individual judges in Hong Kong, the indigenous judges, are independent. But if the rule of law has been circumvented by allowing the PRC to go round the legal system, as I believe that it has, then even though I see the value to the Indigenous judges of having NPJs coming, that ultimately is missing or avoiding the main point, which is the rule of law is gone. And if it's gone, the NPJs cannot continue to sit.
Charlie, thank you. I'm told, I can't see the audience, but I'm told that Joshua Rosenberg is there and has his hand up. So if we can master the tech, here we go. I think you're now live, Joshua, if you can hear me. Do you want to put your question?
He's mute.
Only on this occasion, David. If there's a problem, let me move on, because we've got quite a few questions coming in. And Joshua, when you get a moment, then back to you. Here's a rather sad question from somebody who asks, what am I to tell my fellow university alumnus who lives in Hong Kong and whose wife is locked up as a subversive? I've told him that our judges should stay. Am I right?
Sorry, David.
I have also heard cases which do, on the face of it, give cause for concern. It would be idle to pretend otherwise. Until you have the cases in court, until you have judicial decisions, until, where appropriate, you have appeals, it's very difficult to comment. And for me, as a Hong Kong judge, it's simply inappropriate to comment in particular cases. As I say, it's wrong to pretend there aren't stories which give one cause for concern. But I think one has to see how cases like that progress. But I think they are more likely to progress satisfactorily if the non-permanent judges are there than if they're not.
Thank you, David. And David, here's another question. It's a bit like one of those you get asked when you're asked to, at the end of your opinion, give your percentage chances of the action succeeding. So this question says, can Lord Neuberger provide an example of an action on the part of the CCP which he would personally consider unconscionable and which would therefore, in his opinion, leave him with no choice but to resign? I am in no doubt that I refuse to answer that, but over to you, David.
I'm afraid I'm not going to answer that because one's got to wait and see. I always feel fed up when I listen to the Today program, hear politicians saying, I'm not going to answer a hypothetical question. And now I'm finding myself doing that. I think it's dangerous because it's very difficult to know precisely what sort of thing might come up and what could be done. But I think the obvious example is a serious misuse of Article 55 that Charlie's been talking about.
David,
when it's used simply to get at somebody they don't like, rather than when any real reason arises.
And David, I suppose a linked question which has just come in, who will determine what the threshold is for a walkout? Will that be according to the individual?
Well, I think, as Charlie rightly said, the individual non-permanent judges have to make up their own mind. But inevitably, there is unlikely to be a purely one-off decision by one, although, as you mentioned in your opening, Jim Spiegelman did stand down, and that was done by him after he'd reached his own decision. But I suspect that there will be discussion if something like that occurs. But in the end, each judge will have to make up his or her own mind.
Charlie, anything to add?
Just in response to the question about the person whose spouse is detained as a subversive, I obviously don't know the details of it, but my absolute concern is that the Chinese government are misusing the law in a way that no judge sitting in the UK or in any of the other common law countries apart from Hong Kong would regard as consistent with the rule of law. And the question he asked us was, should the judges stay? Well, I so strongly believe, and this is in a sense a political decision rather than a legal decision, that the line has been crossed, where it's no longer possible to say we accept that towards Hong Kong and towards the law, you can accept that the PRC will respect the rule of law for Hong Kong.
Thanks. Now, here's another question. Joshua Rosenberg, I think Kate was still not able to unmute. So let's just move on to another question. This is about the category of cases that the foreign judges can hear. The question is, will it be satisfactory if the overseas judges are in effect excluded from national security cases and limited only to sitting in other cases? Could it then be said that the overseas judges serve the rule of law in any meaningful sense? In other words, is it okay for them to sit in commercial cases but not, quotes, sensitive cases? David, what do you say to that?
I think one can understand a decision by a government, whether democratic or otherwise, that says we have decided that we will have foreign judges, non-nationals, sitting as judges in our courts. But when it comes to a matter of national security, which is preeminently a national security question, we think it's inappropriate to have foreign judges deciding issues involving our national security. If one sees the PRC in a sinister light, then one can paint that in sinister terms. But as an issue on its own, I don't see it as objectionable. If, for example, it is possible for the PRC or the Hong Kong government, and I haven't looked at the details, so I can't say, to decide whether a case is a national security case. And if one finds that this carve-out is being abused, so they try and pretend cases where they don't want a UK judge sitting is a national security case when it isn't, then that would be a misuse and would be very concerning. But the point in itself, I don't think concerns me. Of course, one may look quite carefully at some of the decisions that are made by the court on this issue if they are said to call into question the rule of law. But the bare question of whether it's seriously objectionable to have non-national judges excluded from trying cases on national security doesn't seem to me to be something which would cause alarm.
Thank you. Charlie?
I mean, it would be absolutely transformative of the role of the NPJs, in my view. It would be absolutely great for a place like Hong Kong to have people of the caliber of David Neuberger, for example, to try commercial cases. But that's not the point of the NPJs. The rubber hits the road on the rule of law, on national security. That's the point which really matters. And if you say to the non-permanent judges, could you deal with, as it were, mainstream crime or family law or commercial law only, you'd get absolutely diamond quality judicial lawmaking and decision-making, but you would have absolutely no element of what the non-permanent judges were there to do, which is to uphold the rule of law, which most comes into question in issues of national security, because that's always what states rely on in order to try to curb the power of the judiciary and the rule of law. So it would be absolutely, I mean, it wouldn't be pointless, because it would be like the examples that David gave, Dubai and Qatar, where those countries have engaged often English judges, retired judges, to sit in their commercial court. But it's saying nothing about the adherence to the rule of law or freedom in those places. And it would be exactly the same here, in Hong Kong, if the position was that the judges, the non-permanent judges, abjured the right or the obligation to sit in national security cases. So I do very strongly disagree with David on that.
I think one has to remember that national security is a relatively small area. I agree with Charlie, it's a very significant area in principle, but the basic law incorporates all our familiar human rights, and judges are entitled, NPJs sit on that. And as I say, one will have to see how it actually works out. And to start expressing deep concern before one sees how it works out seems to me to be unnecessary and premature, and could lead to a very unfortunate premature act, which turns out to be a mistake.
But my concern is based upon the passage of the law in the current context.
Well, no, I think you've got to see how it's carried out.
So here's a question from a prominent in a Temple bencher who says, looking at foreign media, the arguments by Lord Neuberger are not getting through. The perception is that UK judges are giving a veneer of respectability to China's actions in the mainland as well as in Hong Kong. Isn't global perception as important as the reality? What do you say, David, first to that?
Well, I think global perception is not irrelevant. But as I say, just when I was a judge here, the fact that global perception of my role might have been unfavorable or might have been seen as protecting the UK government in some inappropriate way. My primary duty was the people of the United Kingdom to ensure that they had independent judges who applied the law in an intelligent and unbiased way. And my duty as a Hong Kong judge is to the people of Hong Kong to do the same. And the fact that other countries' press may see me as doing something different is of concern, and I would try and persuade them otherwise if they wanted to interview me. But as I say, my primary duty is to the people of Hong Kong.
Thank you, David. Charlie, anything to add before I move on to the next question? We're getting quite a lot in now.
Just that global perception is important, but the only basis upon which a decision can be made about the sitting Supreme Court President and Deputy President is on whether or not the rule of law is sufficiently strong and is not circumventable in the way that I say. If the irresistible conclusion, I believe it is an irresistible conclusion, is that the rule of law has been got round in that way, then the canaries in the mine have got to leave, in my view, or have got to be removed from the mine, or we will be supporting something that is wrong. The consequences of that, I fully recognize. It requires very anxious thought before one expresses this view, because the global perception will be, if the apex judges go, that the rule of law is under threat in Hong Kong. But I don't think it, I mean, to suggest, oh, well, the rule of law is not under threat in Hong Kong is not really the right position at the moment. And so even though it will have an effect on global perception, nevertheless, they've got to do the right thing.
I'm sorry to play games with words, but under threat. Surely, if it is simply under threat, then we certainly should be staying to defend it. If it's dead, then we should go. But if it's under threat, we should be fighting for it, not running away.
Well, first of all, by under threat, I mean it's been effectively circumvented in the way that I'm saying. Secondly, you were saying earlier, David, that leaving is not going to make any difference. Do you think staying is going to make a difference?
I think that staying, I assume, could make a difference. Otherwise, we wouldn't be staying, as you say. And everyone agrees we do support the rule of law in Hong Kong, and the judiciary takes comfort from us. And you only have to look at what the bar, the solicitors and businesses say. Yes, I do think staying will make a difference. And if it doesn't, it's because the rule of law is not being upheld and is shot. And then we go. But so long as it's merely under threat, I think it's our positive duty to stay.
David, I feel I'm peppering you with the questions rather. So here's one for Charlie. Has the Chinese government really gone that far beyond the pale compared to our own national security considerations? And he gives a couple of examples. One is Lord Goldsmith stopping the Al Yamama corruption investigations, and then David Blunkett, when Home Secretary, trying to introduce legislation which would have removed the right to appeal to the courts to all asylum seekers arriving in the UK. And I think the Lord Chief Justice, Lord Wolfe, possibly in 2004, was forced to remark on that issue before the draft was withdrawn. So if that law had gone onto the statute book, would you, Charlie, have supported English judges to suggest that they should stand down?
No, definitely not. I mean, this is a question. These are questions. Those examples are like the examples I think that David gave. You can have very considerable objection to aspects of the law that you have to uphold. So, is it objectionable for the Attorney General to have the power to stop some prosecutions in the national interest, not bring prosecutions in the national interest, but stop them. Most developed legal systems have that power. What I find wholly objectionable about what is happening is the PRC in the current context passing a law that says we can do in effect what we like with people who, in our judgment, threaten national security. And that is getting round almost the prime purpose of the rule of law, which is to prevent people being the victim of arbitrary imprisonment by the government. Of course, every system, as I acknowledged, you can find bits on the edges where individuals would find particular aspects of national security law objectionable. But the national security law passed by the Chinese government 8 months ago is basically saying we can get around the whole legal system in relation to our enemies. And the way they treated the lawyers in the UK, they targeted their commercial interests effectively. And I mean, I don't know whether David's right that they may not be valid sanctions, but it had a very significant effect on some people's commercial interests. And they did it because these were lawyers criticizing them. So I see them in a totally different position from the way that the UK government has from time to time done things that people would regard as not acceptable in human rights terms.
I can't let the point that Article 55 gives them an unfettered right to the Beijing, effectively an unfettered right to deal with people who they don't like. It limits the types of case where they can get involved. And it's those sort of cases where, as I say, Hong Kong is a region of China, and it's cases of the sort that one would expect the federal government to get involved in. The problem is that the federal government in China, unlike in the UK, is not democratic, and therefore it's different. But to build out of that, the argument that the rule of law is completely undermined by Article 55 and adding in the sanctions just seems to me to be a far too extreme point of view.
I strongly disagree with that.
Particularly when one's not seen Article 55 being abused or even used in any way.
You've given the state the power for the state itself, without the equivalent of judicial review, to say that where a serious situation occurs, where the government of the region is unable to effectively enforce this law, that means if we, the executive, take the view that the prosecutions or the investigations by the bodies are inadequate properly to give effect to this very draconian national security law, we can take measures into our own hands. It's the equivalent of saying, if the Cabinet Office takes the view that the criminal law is not effective in providing law and order in any region of the country, we, the government, can decide who we arrest, who we investigate, and how they're punished. And that is so fundamentally inimical to the rule of law. And what's the circumstances in which it's been done? It's been done in the context of the PRC putting pressure the whole time on the government of Hong Kong, not the judges, to clamp down on demonstrations.
We just have to wait and see whether Charlie's analysis of how this law will be applied is right. At the moment,
it says.
Well, it doesn't say that. It says
does.
where the case is complex and involves a foreign country,
or
where the Hong Kong government cannot enforce the law, and where a major or imminent threat to national security exists. So far, it hasn't been invoked.
How have I misstated it?
Because in my view, you've put it a number of different ways, but the essential point is that it applies in certain exceptional circumstances, none of which have so far arisen or even alleged to arise, have been alleged to arise. Let's see what happens.
You're, and I say this with respect, your defenses are fluctuating. At one stage, you said, "Oh, there's nothing wrong with this. There's something profoundly wrong with this." And you're also saying, let's wait and see. Let's wait and see. I can see that defense, but the answer to that seems to be they passed this law 8 months ago. What do they do it for? And I said they did it either to use it or to get the Hong Kong government to clamp down themselves. The idea that a law like this is acceptable is absolutely wrong in my view. How can you defend an executive saying that if the executive takes the view the criminal justice system is not adequately enforcing the law, the executive can enforce the law themselves. That is absolutely contrary to the rule of law.
I still maintain there's no inconsistency between saying that on the face of it, although we wouldn't have such a law in this country, one can understand when you are concerned with the courts of a region, which is what Hong Kong is, that when it comes to certain types of national security issue, it goes to the federal government that is not democratic. Secondly, in terms of it being used or abused, which is what we are looking at, it's been in existence for 8 months. It hasn't been invoked as far as I know, and nobody suggests it's been misused. And I repeat, I'm sorry, I'm sounding like a scratch record, but until we see it being abused, for us to walk away, even before it's used, and it's been there for 8 months, as you say, just seems to me to be letting down the people of Hong Kong in a completely unacceptable way.
What's happening in Hong Kong at the moment is the other provisions of the law are being used through the conventional courts.
Well, quite.
And they are extremely draconian, and they've got this backup power, which again, I do not think it is possible to say that it's consistent with the rule of law. The executive can just pluck people out of where they are and subject them to what they believe, the executive believe, is an appropriate criminal process.
They haven't done it.
But they've just taken, well, okay, well, we've repeated ourselves.
They have.
Right, my lords, we should really draw this to a close because we were meant to finish a few minutes back. There have been tons of questions coming in. Regrettably, I'm not going to be able to put them all to you. Can I just end with one last one? Because we've been talking about canaries flying away, but here's one at the other end of the spectrum from somebody who says, I've been teaching as a visiting lecturer at Hong Kong University since 2010. But our students there are increasingly looking to move to other jurisdictions to qualify because they perceive the rule of law to have been disregarded by the PRC. Can we morally justify propping up the illusion of the continued existence of the rule of law? What would you say to those law students in Hong Kong who have seemingly given up hope on their home? I suppose it's more of a comment than a question, but is there anything you'd like to say lastly in relation to that? David, perhaps you.
Well, I don't think I've got much more to say. No system is perfect. People feel particularly, I don't know whether I need to talk to the students, how far they're talking about the rule of law and how far they're talking about democracy, I don't know. And what are their particular concerns, I don't know. But all I would say in short is that, A, I think you're better off with the foreign non-permanent judges, however imperfect you think the system is. And B, so long as we can accept that the laws are acceptable if not perfect, and that the rule of law and independence of the judiciary are not being interfered with, we should stay and make things better than they otherwise would be.
As has been apparent from what I'm saying, I think that the perception of that university teaches students who are law students is accurate, and that in a sense it's the sort of clarity of studying the basic principles of law and the rule of law that might make it very clear to them that on any basis the rule of law has been compromised in China. So tragically, I agree with the questioner's students.
I have to say, I've talked to other students who have rather a different view, but there is certainly, that is a view which is quite strong among students, unsurprisingly.
Well, that's it. Ladies and gentlemen, you have been favored with a marvelous and very generous demonstration by two legal titans, both peerless advocates, as you would have seen this evening. We're enormously grateful to you both, David and Charlie. It was very good of you to give up your time to come along and address a topic which is so topical. And we've been much entertained and edified by what you said. Thank you so much. My thanks also to Kate Peters, Rosie Humphrey, and Henrietta Amadeo for creating this evening and putting it together. And well, ladies and gentlemen, we're now off to a different virtual world, but you're free to go to the real world. Thank you very much for your attention this evening.